Mhm.
Oh, thank you, Your Honor.
Mhm. All right, so we're going to go on the record in 2024 CR 011808, State versus Teresa Frias. Could I have parties announced for the record for the state?
For the defense, Renee Munoz, Your Honor.
And are you Ms. Frias? All right, so the court received the report back from felony drug court. Counsel, I think that felony drug court would be appropriate for her.
I agree with Your Honor with that, with that assessment, to see if she can be evaluated and meets criteria for that. I know that my clients have experienced trauma in the not so distant past,
Mhm.
in terms of being a victim on an aggravated assault with some pretty substantial gunshot wounds, and she's been out in the community, and I explained the situation with the positives, and that it's addiction is sometimes steps you have to work through, but that the court will likely be recommending that felony drug court. And I was telling her about the program, explaining to her, you know, it'd be some years of probation, monitoring, and treatment as they deem necessary. We're perfectly fine if the court wants to make that referral, Judge. Due to some of the overcrowding issues at the jail, we wanted to see if she could report on outside in the community to see about the evaluations she's been making in support here as ordered. She hasn't picked up anything new.
Oh, and can I have the that printout again?
Oh, yes,
please?
Your Honor. Sorry. Thank you. To address her substance use issues.
All right, so do you live by yourself or there are other people in the home?
I live with.
Hmm?
I live with.
All right. And, oh, I'm sorry, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Chris.
All right, are there any minors in the home?
I have a 16-year-old.
All right. And how many children do you have total?
I have 6 total, but I just have the 6.
All right.
She's with me
And
half time.
I'm sorry?
She's with me half time. Like
She's what?
with me and then with dad. So I get like 2-3 days. She'll be with him. The rest back and forth.
All right. And who is your support system?
My boyfriend
Mhm.
and my, I guess, in-law.
And so do you live with your boyfriend and in-laws? All right. And how long have you been living with them?
I say 8 months because I just got out. I don't know if it counts with the jail time.
Okay.
I was in there for 6 months.
And I will tell you, and your counsel will tell you, I require that probation does field visits. So if you're going to be staying there, probation is going to come in and do field visits. And if they don't want probation doing field visits at their house, then you're not going to be allowed to stay there. You understand? All right. And you all recommended deferred, but neither of you all put down outside the agreement what length you are requesting. So it's
2 years.
Mhm.
That's our understanding, Your Honor.
all right. So what I can tell you is I'm going to give you more than the 2 years. The reason being is because drug court is a 2-year program, and sometimes, well, not sometimes, they have a 2-year program, and the aftercare program is 6 months. Now, whether you're in that program for the full time really is dependent upon you and how you do in the program. You understand?
Yes.
All right. So the court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month until further notice. There's to be a referral to felony drug court. How far did you go in school?
I graduated.
All right, so what are you planning on doing with the rest of your life? What is, before all of this happened?
I was gonna manage it. I love managing.
All right, managing what?
Well, I've always worked at Wendy's. I was at Wendy's for 9 years.
All right, so that's what you want to do? All right. And you know what I always tell people, whatever your dream is, that's your dream. We need people, we need managers. If somebody comes to me and say they want to be a farmer, I'm like, yes, we need farmers. So every place where you see people working, we need those people. So I always tell everybody, no matter what your job is, sometimes we think our job is not important and oh my gosh, what have I been doing with my life? But that job is needed. For example, people will say, oh, that person just bags the groceries at HEB or that person's just a cashier. And I always tell them, don't say just because we need a cashier. We need somebody to bag groceries. We need all of that. I'm still upset that they took away the full service at the gas station, but that's just me. All right, so I'm going to give you 200 hours of community service restitution. 100 of those hours will be deemed satisfied once you complete parenting classes, and another 100 hours will be satisfied if you complete some type of trade school or higher level education. And what I can tell you, some places that you work for, even at McDonald's, they will actually pay for part of your college education or pay for your school. And if you want to really move up quickly in the system, try to go to a trade school and get something in business management or something that will make you indispensable to the company. Because you see at all of these stores where they have now self-checkout, I always tell people, that's a sign. You need to pay attention to that. So can you imagine now you have about 8 self-checkouts in one general area, and they just have one person who works for the company stand there to make sure everybody's scanning things appropriately. Pretty soon, they're not even going to have that person. So that means all those cashiers' jobs are going to be eliminated. So pay attention to, as Briscoe County Junior would say, the coming things, so you can be ready for it, all right?
Definitely good advice. Thank you,
yes.
Your Honor.
All right, I'm going to ask for 90 sober meetings in 90 days. Taking consideration 2024 CR 011807. Yes, thank you. There's to be restitution, if any, and no contact with Gina Rodriguez. And there's to be no contact with Martin Alonso. And Carla, Karla Alonso. And there's also to be no contact with (214) East Mayfield. And that's 78214. Probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
Just asking you if you need anything else, that's fine.
Oh, no, I think we appreciate it.
All right. And did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. I know that life gets hard for people. I know that sometimes we get into relationships and we're like, we wake up and we say to ourselves, how did we get here? But if we are in relationships that are not good for us, best bet is to get out of that. With regards to drug use, let me explain to you. And I tell this to a lot of people. Sometimes they don't believe me, but you see the news. You'll be able to see if I'm telling the truth or not. There are only two things going to happen from using illegal drugs, and sometimes using prescribed drugs. Either you're going to end up in somebody's jail on a regular basis, rotation, or either you're going to end up in prison. Because at the end of the day, possession cases, possession less than a gram, possession 1 to 4. You know, the difference between you and the other person who doesn't get a possession charge, the person who doesn't get a possession charge has used the drug before they are caught, right? So either you're going to end up in jail because you're going to get caught, or either somebody's going to have to identify your body in some field somewhere. And I don't think you want them having to go to your 16-year-old to identify your body. And it will start with, she's missing. We haven't seen her in a while. And then you know what people will say and what the police will say? They would say, but look at her history. Maybe she's just on a bender, right? And then 2 weeks going to pass by. Then popping up on Facebook is going to be your photo, and everybody's going to say, will you please share this? Then the police or some jogger or whoever it is going to find a body in a field somewhere where they're out fishing, or either find a body, you know, on the sidewalk. And then they're going to say, oh, we think it's her. And then they're going to have a relative or somebody who knows you come and identify your body. And I don't think you want your 16-year-old to have to do that, or your family members to have to do that. So whenever you're using, I always tell people, do it. Stop doing drugs for yourself. But if you can't stop doing it for yourself, you know what you need to constantly tell yourself? I don't want my relatives to have to identify my body. I don't want to spend the rest of my life in prison. In this court, to be successful on probation, communication is key. If there's an issue, talk to your probation officer. If you feel as though probation is not addressing it, you can always come back to court and address it with me. Felony drug court, your attorney will tell you that's a great program, but it's only as great as you make it. You have to take advantage of the services they're offering. You understand? And be honest with them. All right? All right. Good luck to you.
Thank you so much.
You're welcome. And thank you for dressing appropriately for court. All right. So here's the thing about that. I understand that sometimes people are dishonest with the court because there are consequences. In this court, I'm fair, but I have to let people know there are consequences. And anytime I'm asking you questions about things, you've already reached an agreement. And normally it's rare for me not to follow plea agreements. Whenever I tell people that I need to know about you so that I can set conditions that will help you, that's exactly what I'm trying to do. Because the last thing I would want to do to somebody, if they have drug issues, I just send them off into the world and don't even address it, because that's not going to be good for you, because that's why you're here, because you have drug issues. All right. So be honest with me.
Thank you.
All right. You're welcome.
David Graham. The model. Tyler Willis.
Mullet. Tyler Pierce Mullet.
Tiger bullet.
When I called the docket, he wasn't here.
Nope.
No.
Oh, he wasn't here?
No.
Okay, well,
You ready to proceed?
I do need to proceed. I'm actually gonna,
All right, can I see the file on Tyler Mullet, please?
we're originally gonna approach and say that the e-discovery has no discovery available.
Deputy Laura, did you make an announcement for him in the hallway?
Still here? Fine. Yeah, stop that.
Court is calling 2024 CR 008387 State versus Tyler Pierce Millette. Could I have parties announce?
And Fair Salem State.
I'm out after on behalf of Tyler Millette.
All right, this hearing was called at 9 a.m. It is now 9:33 a.m. The defendant did not answer docket. Deputy Laura, did you make an announcement?
Yes, sir. It is that I'm in the hallway.
All right, defense, have you had contact with your client?
Oh, yeah.
State? What is your request?
Vote for bond, issue a warrant.
All right, the court will issue a bond forfeiture, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge. And I'll give Norma my mobile number.
All right, thank you.
Be excused.
Yes.
Well, let's keep going. If you want to put it at the bottom, if there's a list of people, because they're bringing them out.
Thank you, Norma.
Tyler Millette. Okay. David Richard Graham. David Richard Graham. Can I see the file on David Richard Graham, please? Kevin Kenneth Deleuze. All right. Hello. And Norma, can you call the attorney for Mr. Deleuze? He needs to be here. And could I see the file on Deleuze, please? Who's here on Kevin Deleuze? All right, just have a seat. We're waiting for your attorney. All right, what? Is this attorney here?
No, it's Dr. Judge.
Yeah, so why not being
Oh,
passed? No, I asked that you call his attorney.
I did.
All right, so as soon as his attorney gets here, then. All right, thank you. Oh, yeah. Okay. Just so you're aware.
Custody.
Today. So your attorney is asking to withdraw. And we will appoint you an attorney who speaks Spanish. Do you understand?
Yes, I understand.
Do you have any objections to this attorney being allowed to withdraw?
No, it's fine.
All right, so I'll allow you to withdraw,
Thank you.
counsel. You're excused.
Appreciate it.
And we will get you an attorney today. All right,
Good.
just have a seat. Counsel, are you on the wheel? Are you on the wheel? Okay, all right, thank you. All right, thank you.
Your Honor, maybe excuse?
Yes, you may.
Thank you.
Renee, do you speak Spanish?
Yes.
Are you able to take a case? It's a possession less than a gram case?
No problem.
All right, it's Mr. Sandoval.
Okay, is he up there?
Yes, Mr. Sandoval, if you raise your hand. Yes. Oh, no, just raise your hand.
Okay.
All right, thank you. Norma Renee said he could do that. He's on page 3. All right, Kevin DeLuz. Who's the state on this case? It's a violation report. It's a violation report, family violence.
Was it on, Judge?
Kevin DeLuz.
Okay, we haven't had any chance to confirm. We have to-
Yes, I just have a seat, yes.
Gotta confirm. It wasn't on the portable check. So just.
My guy's in the box now. Though. Appreciate it.
Arnulfo Escobar.
Which side am I supposed to stand on?
Which one?
That's all.
Making sure.
All right, they're saying they're dismissing your case because of a missing witness. So if the witness appears, then they
Yep.
will refile if they choose to refile. Do you understand?
Yes, ma'am.
So they're not saying that you did not commit the offense. They're just saying they're dismissing it because they have, I'm assuming this is a material witness. Okay. Yeah, thank you.
17th, sir.
Who is here on Gregory Jennings? Who's the attorney for Gregory Jennings? All right.
Please just return, Judge.
All right, Gregory Jennings.
Morning, Your Honor.
Good morning. Hello, Mr. Jennings.
Morning.
Good morning. Thank you for dressing appropriately for court. So where are we on discovery?
I do believe I have received all the discovery. I'm happy to sign off on a 3914 acknowledgement of the same. I did provide the state with what would be reciprocal. I think they're going to investigate further.
All right. And state, were you able to tender an offer? All right, so state, you'll need to tender an offer. How old are you, sir?
40 years old.
Ms. Ferguson, on this case, set this for a plea deadline date, May 6th. All right, your plea deadline date will be May 6th. On that date, you need to let the court know whether you all have reached agreement. If you have not reached an agreement, then you will be put to jury trial. Do you understand?
Yes.
All right, once you sign the reset form, you are excused. All right, thank you.
Thank you, Judge.
You're welcome. Have a good one.
You too. Or not that I'm leaving.
Okay. All right, on Alan Menares Pettis, we need an interpreter. Not without an interpreter. David Richard Graham. David Richard Graham.
He's been appointed by the state to testify in trial May 5 to May. He'll be here. Sorry. We just might let her know that, you know.
Yes. Yes.
Good morning, Your Honor.
Good morning.
We just spoke about Mr. Jennings.
Mhm.
You gave him a plea deadline of May 6th.
Yes.
Just to make the court aware, he has been subpoenaed by the state in another case
Mhm.
for May 5 through 9. So he certainly will be here in the courthouse, but we may have to borrow him from
Okay,
another
we'll
place
see if,
if that comes about.
yes. All right, thank you.
Thank you.
And this is a judge's. Are you all ready on Kevin DeLuz?
Yes.
Yes, all right. Think so.
We did confer, Your Honor. I didn't know, I hadn't seen the violation report, so I did review the violation report.
Okay. All right, court is calling 2025 CR 0037995 State versus Kevin Kenneth DeLuz. Can I have parties announced for the record for the state
Ashley Jones for the state.
defense?
Zachary Munoz for the defense.
And are you Mr. DeLuz? All right, off the record for a moment. John Young.
Don.
Hi. Oh, thank you. If you can move to the other end with your client, we're on the record. All right, we're back on the record. Are you Kevin DeLuz? All right, we're here because there's a violation report. It's the second violation report. Have both parties had a chance to review it?
Yes, Your Honor.
All right, they say that he's in the inclusion zone and that he keeps making unauthorized stops while he's on GPS. What are you all requesting, state?
Your Honor, I mean, at this time, the state would be asking for a bond to increase, based on the violations.
All right, so why is your client violating his GPS?
Well, Your Honor, I guess first off, for an actual bond increase, I think the state would need to put on actual evidence.
No, they do.
Yeah.
So.
But Your Honor, my client is having issues in getting in contact with his probation officer. He's leaving messages to let him know he's going in for jobs, but he's not. Unfortunately, my client is in a desperate need to get there, and then he's not given. I don't think the problem is he's not given a sufficient 24-hour window. He's giving less than 24 hours notice to his officer, and so I think that's what his continued violations. Now, I understand a lot of
Some of these violations, they are not a place of residence.
no.
I mean, they're not a business, they're places of residence. For
Yes.
example, he's in Converse at Northampton Park. He's in Converse at a previous residence.
So, Your Honor, my understanding is my client was actually moving from this the 8134 Kentura Mills, and you're currently living
At 8545 Copper Sky.
okay. And he's currently living at 8545 Copper Scott.
Copper Sky.
Copper Sky. Sorry, Your Honor. And so I think those addresses were the liquor stores are actually if you turn to the page to the GPS coordinates, it's within 300 feet. If you look at the next in that same shopping mall, the next business over is actually a barber shop. My client is a licensed barber. He is trying to get additional employment. Prior to this case, he actually owned his own business where he would go out and work on IT. He still does do that. However, given the nature of this case and the inability to leave his home and coordinating with that, he's trying to find a more stable employment 9-to-5 type of job.
No, but does anybody want to have the pretrial services officer zoom in? Because there are other things that are being said in this report.
And Your Honor, I mean, we're not going to contest that he's not going to AutoZone, Jiffy Lube, or these
No,
locations.
but it says the above mentioned defendant has been previously admonished multiple times for making unauthorized stops. When questioned, the defendant, he confirmed that the following listed unauthorized stops were not work-related. So they're saying he's confirming that they're not work-related.
So, well, my client is stating to me, and we can put him under oath here, but he's stating that the location that he just is describing that he was an unauthorized work-related stop was Walmart, which was for essential needs. And I will in some of these, Your Honor, the Dollar Tree, the Chef Joe AutoZone, Jiffy Lube, those were to get car parts. Family Dollar, those are to get groceries. So it's my client. I understand he's not necessarily following the 24-hour window that his officer wants. Unfortunately, some of these needs are he doesn't realize he needs them. I've explained to him that he needs to let him know far in advance and keep written documentation of
Well,
such.
I will tell you, somebody changed his conditions. It was not the court, because I see here his previous condition was no contact with the complainant and full house arrest. Then someone came back and changed it to no harmful or injurious contact with the complainant and partial GPS. Here's
Yes.
the court's problem. He's not following GPS rules. If you don't want to follow GPS rules, then you're not on GPS. And I tell people all of the time, if there's an issue, you can come to the court. If you had an issue with your pretrial services officer being unable to accept your call, or you being unable to contact your pretrial services, all you had to do was make an unauthorized stop to the courthouse, the 187 District Court, which located on the 4th floor. That's all you had to do.
Yeah, Your Honor, and that's partially a scheduling error with myself. My client has reached out to me to ask for a modification to GPS tracking only to assist him to stop having these issues. That is going to be a request that I believe is on file, but I understand it's not set for today. Your Honor, I was the attorney that did modify it. That modification was based upon receiving an affidavit from the complainant stating that she was not in fear of my client. She actually recanted one of the allegations as
All right,
well.
this is what's gonna happen. State, do you have witnesses?
We don't, Your Honor, at this time, however, if the court would like to hear from the pretrial officer of the state, then we can try and take a hold of them.
All right, we can call in the pretrial services officer. I say we, the state.
Okay.
Are you gonna object to them appearing by Zoom?
No, Judge, Your Honor.
All right, Ms. Ferguson. If you can have the pretrial services officer zoom in on this case. All right, just have a seat and we will continue.
Thank you.
You're welcome. Who is here on Alexander Rodriguez? Good morning. Your voice carries. He was able to hear you.
Sometimes, and then I have people sometimes who say they still can't hear me.
All righty, so on this case, you're scheduled for jury trial.
We're ready, Judge.
We're currently in a jury trial, can't do two trials at once. So Ms. Ferguson, recall this for jury trial, April 21st. All right. And they will bring you over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. If
We've
there's an issue with it, let the court know.
We've already taken care of it, Judge.
All right, thank
Thank
you.
you.
Oh,
Oh, no.
defense. I have some motions here
Yes,
for you.
Judge, it's one motion. They just stapled the motion in the order separate. I'm sorry.
And what was the previous amount that was given?
Oh, no, Judge, I'm
All
sorry.
right. If you can find
Let
out
me
for
go
me what it is.
Do you have the file?
Oh, can I tell you, somebody took my pen. I think it's the pen.
I will give you another one, but you have to promise me I get yours.
Oh, yes, most definitely. Yes. Someone took it.
Let me get her.
All right, thank you. No, I didn't give the last one away.
I ran out, gave out over 302 days at the office.
Oh, wow.
But mine hopefully will be in this week.
Okay,
So on this one, I'm trying to figure out,
is it not, is it in the file? Did she give you the clerk's file?
no, this is what our files are.
Oh, okay, yeah. So I need to see what the amount was that was previously granted. In the back? Okay.
Well, let the attorney know.
Okay, and we have the interpreter here. When you all are ready, let me know. Are you ready with the interpreter?
Yes.
Okay. And who's here on Juan Manuel Clara Rascon?
I am, Judge. Good morning.
All right, and your client, Spanish speaker too. as
Yes,
well.
Your Honor.
All right, we have the interpreter here. If you want to speak to the interpreter to have him brought up.
I've spoken to her already, Judge.
All right, let's bring her up and your client. Didn't I just attend your retirement? Ah, it happens. Let me see here. All right. Let me pull this up on Odyssey. All right, so we're here for jury trial.
Yes, Your Honor.
Court's currently in a jury trial. Ms. Ferguson? On this case, If you recall this for jury trial on the 21st,
Yes, sir.
unless your client wants a bench trial.
April 21st, Your Honor?
Yes.
Okay.
He doesn't address unless your client wants a bench trial. He's April 21st.
Yes, Your Honor.
All right. All right, sir, do you have any questions? No. All right, so you'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. Counsel, if there's an issue with the clothing exchange, let the court know and I'll see if I can help expedite.
Yes, Your Honor.
All right. Do you have any questions, sir?
No.
All right, thank you. All right, who's here on Alan Mineros Pettis? Good morning. Good morning. All right, court is currently in jury trial, so we can't have his jury trial today unless you would wish to have a bench trial.
We would not, Your Honor.
Okay,
We'll go ahead and stick to our jury.
thank
trial.
you for being direct.
Yes.
All right, so we're currently in a jury trial, so we can't do two trials at the same time. You understand? All right, we're calling you back for April 21st for jury trial. All right, thank you. You'll be brought over dressed in whatever clothing, civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. If there's an issue with the clothing exchange, let the court know.
I expect that to be done today.
All right,
So
thank you.
We should be good to go.
Is there anything else?
Thank you so much.
Oh, you look at that. Donata.
Thank
All
you.
right, thank you.
Thank you.
Thank you. Hey, let me ask you something.
Yes,
Are you gonna need, do you need an interpreter?
I think we had talked about that the last time I said no.
All right, so here's the thing. If you want an interpreter, then we'll give you an interpreter.
Okay.
If you don't need an interpreter, then we won't give you one. Do you need an interpreter?
No.
All right, let's go on the record.
Thank
Court
you
is
so-
calling 2021 CR 6862, State versus Alan J. Mineros Pettis for the defense.
Dante Dominguez for the defense.
And are you Mr. Alan J. Mineros Pettis? All right, if you could speak in Spanish. All right, and could you raise your right hand for me to the interpreter? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. Can you raise your right hand for me? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, speak in Spanish for now, okay?
Sí.
Yes.
All right, the questions I am going to ask you are not about the facts of the case, and state you may be excused. The only questions I'm going to ask you is in regards to an interpreter.
Sí.
Do you understand?
Sí.
All right. Now, the reason why the court said we will have an interpreter here, because I think at first you were saying some words you don't understand. So we have an interpreter here. For your jury trial, we can have an interpreter as well, who will translate from English into Spanish and Spanish into English. Do you understand?
I do. I see.
Spanish.
Sí.
All right.
I do.
Okay. Do you wish to have an interpreter at your trial?
No.
Do you wish to have an interpreter for any of these proceedings?
No.
No.
All right, do you need an interpreter?
No.
No.
All right, I know ma'am is not the Spanish word for ma'am. What's the Spanish word for ma'am?
Señorita.
All right. Oh, look at me, I'm a señorita. I like that. You know, they always say, well, in French, you have different sayings or different words if someone is older or younger. So I'm a señorita.
Same in Spanish, Your Honor.
All right.
That was, yes, ma'am.
All right, then we can go off the record. Now that song is gonna be in my head. The señorita song. All right, so we'll see you back on April 21st.
Okay. then.
And I'll notate that you do not need or want an interpreter. All right, thank you.
Yes, sir.
Well, you too.
Thank you, Judge.
You're welcome.
It's gonna ask to approach on, I'm sorry, online, so if you don't mind. I don't want you. Your Honor,
Yes.
before the interpreter's excuse, may we announce quickly on the matter I was just appointed on since my client's a Spanish speaker?
What is Aldo Mendoza?
Aldo Sandoval, Your
Can
Honor.
I see the phone, Aldo Sandoval? And if you can have Mr. Sandoval come down.
Yes, Aldo, ¿puedes venir aquí?
All right, thank you. Just 1 second.
Of course, Your Honor.
All right. On Aldo Sandoval.
Yes, Your Honor. Correct, yes, ma'am. Recently appointed on this case today, Judge, got his basic information. Requesting a reset to go over the existing evidence, as well as speak with the immigration attorney regarding potential consequences.
All right, Ms. Ferguson, I need a 30-day reset.
I'm gonna be out that week. Norma, can you do maybe perhaps the week after?
Straight.
Yes, the 19th.
Perfect. Yes. Actually, I'm swamped that day. Do you guys have the 20th?
Yes.
20th.
All right, we're gonna bring you back on the 20th of May.
Perfect.
Do you have any questions, sir?
No, that's fine.
All right, thank you.
Or,
Maybe, yes, thank you so much. It's good seeing you.
please. Señorita, may I approach the bench?
Yes.
No, I'm just messing.
I'm like, wow.
It's me thinking. They're gonna TIC one. We're gonna play on the DWI.
Yeah.
Thank you.
All right, Eugene Navarro. Is he still downstairs?
Sorry, who judge?
Eugene Navarro.
No, we have him in the back bench.
Oh, can you have him come out just briefly?
You wait for me here.
All right, thank you. Yes.
I
Okay.
gave it to you. It was 2,500 and then 1,500, but this is a CSA trial case.
Okay. So you say 2,500, then 1,500?
Yes, and I gave you the orders,
Okay.
the previous orders. With a lot of witnesses.
All right, I will add an additional 5,000.
Thank
If
you.
more is needed, just let the court know.
Okay, thank you, Judge.
And then I will hand it to them and they can put it, get you a copy.
Perfect, thank you, Judge. Let me take it back. May I leave it with her? Okay, thank you.
Adolph Mendoza. All right. Mr. Mendoza, thank you for dressing appropriately for court. All right, counsel, on this case, where are we on discovery and has an offer been tendered?
Yes, Judge. With regard to discovery, it seems to be intact. I recently today got access to 4 large files that I had to bring the external drive on, so I did get those. So I'm needing some time to review that as well as the additional discoveries. Voluminous, there's at least 10 to 15 videos I need to review. So requesting a reset to review that new discovery as well as the existing, Judge.
Alright.
Also, in reference to this case, I did file a motion to modify conditions of bond seeking removal of the GPS device. He currently still has it on, Your Honor. He's had it on since his release on pretrial services since July 29th,
All right,
2020.
so let's take up one thing at a time.
Yes, Judge.
Ms. Ferguson on Mendoza. Give me the discovery date for that is going to be May 20th, since you're already going to be here, counsel.
Perfect. Yes, Your Honor. Thank you, ma'am.
And let me see. Now, could I have the motion pulled on Mendoza? It's a motion to modify bond conditions. And State, are you ready to proceed on the motion to modify conditions of bond? All right, court is calling 2025 CR 001538, State versus Adolph Mendoza. Can I have parties announced for the record? State? Defense?
Renee Munoz.
And are you Mr. Mendoza?
Yes.
All right, defense has filed a motion to modify conditions of bond. The defense is requesting removal of GPS.
That's correct, Your Honor.
And State, are you prepared to proceed on the motion?
With regard to the motion, Judge, I don't believe there's any witnesses that necessarily need to be called. The circumstances regarding it are that July 29th, he was released on pretrial supervision, and that's of 2024. He's been on full house arrest GPS from that day, and he's still currently on that condition of full house arrest.
And I'm sorry, what date used to say?
July 29th, 2024.
All right.
And there have been no violations rendered. He's been compliant with pretrial services as well as seen Center for Healthcare Services as a condition of that special needs unit bond. He's currently on medication. He's doing everything that the court is requiring him to do in terms of bond conditions. In fact, my client told me that he went to the pretrial office and, the pretrial officer recommended, since he's doing so well, for him to, bring it to my attention. We can, ask the court for some relief in terms of the GPS monitor. So that prompted me to make the request to remove the GPS monitor based upon 8 months, 10 days, no violations or incidents of any sort under full house arrest GPS.
All right, so what I can tell you, sir, is I don't like for GPSs to be removed. And then 100% freedom, because then people fall off track. State, do you have any objection to tracking only?
State would prefer partial GPS. So.
All right, and so why are you requesting partial GPS?
Because the defendant, Mr. Mendoza, and the complainant neighbors. I think it's important to keep track of where Mr. Mendoza is. Greater degree of freedom. Additionally, Mr. Mendoza has a greater application prior acts.
Okay.
Your Honor, My client notified me that he's currently not working. His doctor doesn't allow him to work. So essentially, without it being changed to tracking, it would essentially render him still full house arrest GPS.
All right, so would you like, state, just a moment. State, would you object to partial GPS for medical appointments with a curfew?
That sounds acceptable, so no, would not object.
All right, so if you all can figure out a curfew time, so he'll be on partial GPS with curfew. All right, so if y'all will step back.
So with that, Your Honor, the curfew time, he would essentially be allowed to be out in the community, but aside from certain hours? Or,
Yes,
okay,
so the partial GPS, when I say partial GPS for medical, and I'm gonna have, this is gonna have to really be written very well for pretrial services. This is what I mean. Whatever time your doctor's appointment is, he's allowed to go. Whatever medical, he's allowed to go, even if it's outside the curfew. But if there is not a medical issue, then he is going to be on a curfew.
Okay.
So for example, if on Monday he doesn't have a doctor's appointment or any medical, then he has his curfew, whatever time that is you all agree to. If on Tuesday, let's say you all agree that his curfew is 5, well, doctors are usually, let's say you agree his curfew is 3 p.m., but his doctor's appointment is at 4 p.m. Well, he'll be allowed to go to that doctor's appointment outside of his curfew, but then
okay.
immediately return back home.
So the curfew situation is like, say he wanted to go to the grocery store, and as long as it was in that curfew, he'd be allowed to go to do something
Yes.
like that. Okay.
Yes.
That sounds good. Yes, Your Honor, we'll confer regarding the times.
I wanted to say something.
Mhm.
I want to get out because I usually take my kids to school and to work. That's why I really want to go, so I can take them to work.
Well, if you are on a curfew, then if the drop off and pickup is within the curfew window, then you'll be allowed to do that.
I want to make sure, because that's the reason why I want to get this my kids.
All right,
Yeah, we'll
yes.
we'll work on it.
So defense, state, that's the agreement that you all have, that he's to have partial GPS for medical appointments with curfew. So I'm gonna hand the defense the order, and once you all
Yes, sir.
put it in there, that's what the court will order. You'll need to be back here on May 20th for discovery. Counsel, if you will get the reset form, you're excused once the reset form is signed. And once you all do that, I will sign it and you can make a copy and we'll make sure pretrial services has it.
Just to clarify, Judge, if when we come to this agreement and it's written on the order for your signature, do we have to reapproach on this one? Okay,
No.
it's on the side. Okay, great.
Yes.
Thank you.
You're welcome. And Deputy Laura, do you have that other person? He hasn't come in. Right? Okay. All right, on Deleuze, can you come forward, please? All right, what I'm being told, his pretrial services officer is out of the office. So, Mr. Martinez, could you unmute yourself?
Yes, Your Honor. Joanna Martinez at your service.
Hi, thank you so much, and thank you for zooming in very quickly.
Yes,
All right,
ma'am.
so here's my question. On Deleuze, are you connected with this case or are you the supervisor? How are you connected with the case?
Mr. Bohack is currently his supervising officer. Since he is out on a personal leave, I'm covering the caseload for the time being.
All right, do you have any objections to his testifying about this? Of course, it will be hearsay.
Yes,
I
ma'am.
would have to object, Your Honor, simply because if there is any questions regarding my client telling him that these aren't work-related, unfortunately, Ms. Martinez didn't have that conversation directly with Mr.
All right.
Deleuze.
All right, so thank you so much for zooming in. Please do not leave, Mr. Martinez. We're
Yes,
back on
ma'am.
we're back on the record, and 2025 CR 003795, State versus Kevin Kenneth Deleuze. That party's re-announced.
Ashley Jones for the state.
Zachary Munoz for the defense.
And are you Mr. Deleuze? All right, so his pretrial services officer is not available. The person who's come to testify will be Giovanni Martinez.
Yes,
The
ma'am.
Thank you. The defense has said they're going to object to hearsay because he's not the pretrial services officer. And what I can tell state, I would sustain that objection. So this is what the court is going to do. And Mr. Martinez,
Yes, ma'am.
the court is going to alter and amend his conditions to full GPS.
Yes, ma'am.
You're going to be on full GPS. So you're not allowed to leave your home.
Your Honor, with regards to employment, if the court were to modify it to full GPS house arrest, my client would unfortunately lose his job and then at that point lose his ability to afford the house he's currently in.
Well, what he needs to do is he needs to provide adequate proof that he is employed and where this employment is located, and then the court will reconsider.
Okay, Your Honor.
So he'll need to provide that. And what I can tell you, if you provide that, I'm not trying to make someone be unemployed or not have funds, but if you provide that, then the court will strongly consider allowing you to work on GPS. And let me explain to you what the court's problem is. The court problem is that the report is stating that you are not abiding by their rules and that they've told you before, these are the rules. You have to abide by the rules. I always tell everyone who comes in this court, if there's an issue, then we can come in and we can address that before we get to this point. And this is your second violation report with the court. Normally, we can go off the record. Normally, you know what other courts usually do? They just go ahead and rule on this. There would already been a warrant for your arrest based upon the nature of the offense. And the problem is with the nature of your offense, they have to know where you are located. I'm not the one who puts you on GPS. A magistrate judge or some other judge puts you on GPS, not me. But the rules that judge put in place for your GPS are the rules that I follow. Now, if it comes to a point in time where someone wants their GPS removed, or if they want a curfew or tracking or something else, that's something else we can discuss. What I can tell you in this court, asking for forgiveness instead of permission is not a good way to go. So all you had to do was come in and say, this is what's going on in my life. Can we modify GPS? And sometimes the state will agree on the modification. Sometimes they will not. But what I can tell you is if the state and the defense can't come to an agreement, I'll listen and I'll make a decision. Maybe I'll agree with the state's assessment, maybe not. Maybe I'll agree with the defense's assessment, maybe not. And then sometimes when states and defense, when you all have agreements and I don't think it's appropriate, then I don't agree with it. I don't do it. So let me just tell you what I need from you so that we can be clear. You will need to provide proof of your place of employment, and you will need to provide the hours that you work. And only then will I consider partial GPS for employment. And at that time, what I can tell you, it will be for employment only. You understand? Because I have to act when there is, based upon the nature of your offense, and there are these violation of GPS inclusion zones. And really it's for your best too, because the complainant could say, you know what? This is where I was and I saw him. Or this is where I was and I saw him. You don't want that to happen. You understand? Yes.
There is no complaint.
Yeah.
There is no complaint. There is no complaint.
Your Honor.
Stop. I'm done.
Thank you.
Unless I speak about something else.
No, it's just.
Let me explain something to you. You're saying that there is no complainant. I don't know anything about the facts of your case. You know why? Because nobody has presented facts of this case to me. All I know is what you're charged with, and what you're charged with is continuous violence against the family, right? So when there are charges, continuous violence of the family, robbery, murder, whatever it may be, the state, in some cases, you're saying that there is no complainant. There may not be a complainant that's going to come to court, but a complainant exists. Although we have had a case indicted before, none of these prosecutors indicted it without a complainant. But normally, there's supposed to be a complainant. And in your case, looking at the indictment, there's a complainant listed. So there is a complainant. Whether or not that complainant is coming to court or not, that's something for the state and the defense to worry about. I'm just here on this violation report. And what I'm telling you, other judges, and in the past, defense attorneys will tell you on these violations report before I took the bench, you know what previous judges would do? Just do a bond forfeiture or do an increased bond or remain without bond, and you will be brought over in orange. So what I'm telling you is you're going on full GPS. Your officer knows that it's going to be full GPS. Counsel, if he has employment, he needs to provide the hours and proof of employment to pretrial services. And then I will consider whether or not I will allow him to work while on GPS.
Yes, Your Honor. Well, if I may, he has provided that proof to the pretrial service officer who's not here today. I will have him email me that information again and provide that to the court coordinator as well as directly to Mr. Martinez.
Well, and you all should ask Mr. Martinez if he has that. If you want to find out from Mr. Martinez if he has proof that he's employed and what his hours are, then
yes,
I'm assuming there will be no objection to hearsay.
no objection at that point.
State, would you have any objections to Mr. Martinez?
No, ma'am. I'm pretty sure Officer Bohack has got full credentials and everything. I'd be more than happy to provide him with his attorney. Just need a contact information. I'll send it to him right away.
Okay.
All right. Thank you. What's your email address?
It's
Well, let me have you write it down for me. And Officer Martinez, thank you so much. I'm going to put in the chat the defense counsel's email address.
Thank you, ma'am.
And Rick, I'm sorry, what's your last name? Pena. All right, and if you're going to include the state's attorney, Rick Pena, is it Richard really? Ricardo.
And Ashley.
All right. So if you can include Ricardo Pena in the email as well, he's the state's attorney. Okay, it's Zacery?
yes, ma'am.
Okay.
Yes.
All right. All right, they'll send the email.
Thank you.
Thank you. And then we're also here because he said today, where are we on discovery?
I didn't realize we were already set. Your Honor, I believe we received the discovery on one of the altercations, the other altercation I need to get with the state. I didn't realize it was actually set for today.
I figured since you're already here,
Yes.
so that way he won't have to come back.
I will get with the state and confer with them about some additional discovery I do need.
All right.
We'd ask, I guess at this point, for a 30-day reset on the actual case.
Okay, just 1 second. Let me go to the summary. All right, it's actually set on May 5th.
That's perfect.
That's a good.
Yeah, that's
date?
a good date. I will
Okay.
continue to confer about the discovery.
All right, so we'll recall you from Norma. If you can give them a reset form for May 5th. All right, thank
Thank you, Your
you.
Honor.
You're welcome. Thank you, Officer Martinez, your excuse.
Thank you, Your Honor. It's a pleasure. Have a good day. God bless.
All right, you too. God bless you too. Yes. All right. Eugene Navarro, if you can come down. Yes. Hello.
Hello.
Hi, so anyway, it's your attorney's birthday, and he's spending it with family, as he should. So we're gonna recall you for a different date, and your attorney will be here on that different date. Ms. Ferguson, recall this for April 15th. All right, we'll bring you back on April 15th. Okay.
Thank you, Your Honor.
All right, you're welcome.
Well, did you request it?
Let me see. I think, just one second, let me put this in the system. Who's here on Baldomero Chapa? Morning. We are currently in a jury trial, as you know, so we'll see you back on the 21st.
Yes, ma'am.
All right, Ms. Ferguson, if you can give them a reset date for April 21st. And thank you so much for addressing properly for court. All right, once you sign the reset form, you're excused.
Thank you, Judge.
Did Marissa give you hers? Oh, she got a wicked one. I'm gonna take a picture, send it to my wife. I just got some money in trouble. My wife. Same, I'll find her. And come on.
Who's here on Ezekiel Neely?
We're present, Judge.
And then after that, Mr. Zamora, it will be your case. All right, so this is final day for discovery.
On Mr. Neely?
Yes, is it, we're here for discovery?
No, Judge, this restitution, I think this,
Sorry, not discovery, restitution.
And if defense counsel will allow me,
Yes,
the last time that we were here was for Mr. Carter
Yes.
to produce an itemized receipt. He sent me this message yesterday. I have not been able to get an itemized receipt. Insurance cannot provide one at the billing office for the hospital. It's in Houston and has not returned in yet.
all right.
That I understood that there would not be very much that I can do, considering the court schedule in order, and he responded, I understand.
All right. Thank you very much. All right, so then if you want a record, I'll give you a record, but I'm not gonna order any restitution. He'll have to seek other avenues. All right,
Judge,
yes,
and can we just confirm the restitution that was ordered the last time we were in court?
I think it was for our new folk Bernieda.
Yes.
The amount of $8,700, more or less.
I have
let
70.
me tell you what I have.
Thank you, Judge.
All right. There is to be for our new folk, Grenada. It is, I have, yes,
He said thank you to me and I said you're welcome.
oh, okay. I have $7,600. Is that what everyone has?
That's what I have written down.
All right,
And
And-
then for James Tarter, nothing, correct?
yes.
Okay.
All right, and the reason why, and you know what, let's go on the record. Court is calling 2024 CR 3316 State versus Ezekiel Neely. Could I have parties announced for the record?
Andrew Harris, State.
Good morning, Your Honor. Alfonso Cabañas from Mr. Neely.
And are you Mr. Neely? All right, so this restitution hearing was called so that the complainant could provide an itemized list of expenses related to this cost number. State, is there an itemized list?
No, Judge.
And what the court will say is we have had a restitution hearing in this case on October 17th, October 31st, November 21st, December 3rd, December 10th, February 6th, and it was set for February 7th, but the court was in jury trial. And then it was recalled for today for restitution hearing in regards to Mr. Charter. The court has set this for a restitution hearing many times. Defense, what are you requesting?
Judge, with regards to Mr. Tarter, I'm requesting a zero restitution amount since there's been no proof submitted by Mr. Tarter to the state of Texas.
All right, that will be granted. There will be no restitution under this cause number to Mr. Tarter. Mr. Tarter will help to seek other avenues in regards to restitution. Is there anything else?
And then, Judge, I believe that should be, I hope, the last defendant. And so I'm hoping that this is the last restitution hearing for Mr. Neely.
We all can hope, but I think that was the last person. If there's someone else, then the court will entertain it.
As far as I'm aware.
All right, thank you.
Thank you, Judge.
All right, Anthony, Zamora,
Yes, ma'am.
Mr. Ivy, what is the update?
In the box, Your Honor.
Oh, he's in the box.
He is.
Oh, Mr. Ivy, come down. Wow,
Nobody's seen you for a few years. She's asked, you.
yes,
Okay.
we thought this day would never come. I feel like Dorothy.
It's been, the last time you saw him, Judge, was a week before COVID hit.
If only Glenda would have told me before to use the red shoes that I already had. Although as a child, I never was a fan of Glenda because one, I always said those were not her shoes to give.
I just saw something on that, where
And
she
then-
ended up being the one in power.
Oh, yes.
She knocked everybody off, the Oz, the Wizard.
And she had other people to do her dirty work. So, and then involving a child to do her dirty work.
I just saw something about that a couple weeks ago.
So I've always rooted for the underdogs. All right, so on this case, he has been in federal custody. So
Yes,
your
Your Honor.
cases.
We are conferring, we did, obviously, this case just popped back up since we just came back from Cedar County. As the state was reviewing, we did notice that we were missing hospital records and CPS records, so our advocate is ordering that. Other than those needing to be turned over to defense, that would just be picking up from the state's perspective.
And that's for the, sentence.
3440 hospital.
All right. Anything else?
That's all.
All right, Ms. Ferguson, recall this for April 21st.
Thank you, Judge. And we're in touch, and I saw him 2 days after he was brought back, so everybody's,
Okay.
we know that this is old, and we're trying to see what we can do,
All right.
okay? I don't know if we're gonna be able to do it, though, Judge.
Okay.
Okay.
All right. So we'll have him brought back on April 21st. Thank you. And Norma, make sure that we put a hold on him. Adrian Morales.
Morning, Your Honor.
Good morning. Thank you for dressing appropriately for court. All right. Where are we Ah, this is a hearing.
Yes, ma'am.
So have you all had a chance to confer?
We have, Your Honor.
All right, the court is calling 2025 CR 002830 State versus Adrian Morales. Can I have parties announced?
Andrew Harris, Salem, for the state.
Sergio Ibarra for Mr. Morales.
All right, are you Mr. Morales?
Yes, yes.
All right, so the court received the first violation report. It's for high reading. Have you all had a chance to confer on the violation?
We have, Your Honor.
And is there agreement?
I believe there's a, yes, we're in agreement with the recommendation of the state, Your Honor.
And what is that recommendation? And nothing else?
Right there.
I'm sorry. Nothing else, Your Honor. From that, I can, I'm happy to explain to the court, and
Yes.
he would be happy to explain to the court. He had family over. When I talked to him about this, he had mentioned that, you know, he had no intention to drive. I don't intend to have any drinks outside of the home, but I explained to him the requirement is no drinking whatsoever. I understand his intentions, but now that we've had a chance to talk about it, and I said in no uncertain terms to abstain from drinking alcohol, he's perfectly fine, and he's able to meet that requirement, Your Honor. I do not anticipate any further violations.
This is what the court is going to do. The court is going to continue with a mixed interlock. I'm going to add the alcohol awareness course. I'll ask that fees be waived, and there's to be 60 sober meetings in 60 days.
Understood.
And your next court date in this court, you're already set, I believe, for May 15th.
Yes, ma'am.
All right?
Yes, ma'am. Thank
You're
you.
not allowed to drink.
Yes, ma'am.
Do you understand?
Yes, ma'am. Understand.
All right.
Fully.
Thank you. Once, does he need a reset form?
I don't believe so, Your Honor, but just to be on the safe side, I probably will ask for one.
All right, Ms.
Yeah.
Ferguson, they're already set in the system for May 15th. If you could give him his reset form and double check that there's no issue with it.
Thank you, Judge, for your
You're
time. I
welcome.
appreciate
Thank
it.
you.
Thank you.
Oh, and I'll give you this in just, oh, you can keep that. But I need to give you the docket sheet for it. Sorry, that be on that. Let me just write something. There you go. Thank you. Jacob Cannon. Who's the defense attorney for Jacob Cannon? Andrew, go. All right, whenever they're ready. Kenneth Howie.
She's in custody.
All right, Mr. Howie. All right, so on this case, I've signed all of the documents that are needed.
I understand, Judge, and obviously we want to get moving on this, is Mr. Howie's been in custody
I'll come down.
this
Mr.
entire time,
Yes,
and so
and so what I can tell you.
is I'd like the setting as quickly as possible, Judge, for obvious reasons.
on your case, but it's been very difficult because the DA's office are recused from hearing, I'm sorry, from being the opposing counsel in this case.
Yes, ma'am.
So legislatively, there's a certain process I have to follow in order to have someone represent or stand in as the attorney for the state. So I have to appoint a pro tem. Here's the problem. The legislature, when they pass laws, nobody ever thinks of the consequences. Years ago, you know what I could do? I could look in the courtroom, and I could see if there's an attorney who's been a prosecutor before, would you take this case? And it'll be simple as that. It would be quick. You all could probably have already concluded this case. But now I'm not allowed to do that legally. So the AG is saying that they will do this case. However, just one second. They want specific times and let me see if I can find the date for you, because they want
And Judge,
45 days or 60 days.
I'd like it, and Judge, I would like my client to just be made clear in front of my client that both the court and I have been trying to push to get someone appointed so we can resolve this case.
And let me just tell you, Mr. Howie, your attorney and I, the court coordinator, have been trying to get someone to stand in for the state as pro tem. It's just been very difficult.
I understand, Mayor.
All right. And so your attorney will tell you, I don't like for cases just to sit around in this court. Sometimes people say I move it too quickly, but
Is it possible that I get a signature bond from my lawyer to get out?
what I can,
Because
well,
my parents are elderly and my brother, especially his brother, is undergo some.
Here's
open
prob-
heart surgery.
here's part of the problem with that. I would need an attorney to stand in for that, but they're saying that they would need 30 or 45 days to prepare for just the motion to revoke. But maybe it won't take that long for them to prepare just for bond issues.
I'm gonna go ahead and file a motion to set bond today.
Mhm.
And then my preference, and I don't even care if they come in by Zoom, Judge.
Okay.
I need to get a bond set in this case. I need to go ahead and work on that because Mr. Howie's right, his parents are elderly. They do
Mhm.
want him back. They're not the complainants in these cases, and so
Yes.
I want to move forward on that.
All right, let me see. Just one moment. I'm trying to find.
That's more appropriately for the judge.
Mm.
I'm the one-
No, let me
last
just-
year in January 2024, 2009, I said, I'm the one that said, yeah, Hollywood for this.
Judge, this is the most appropriately he could dress for.
Oh, yeah, and I'm fine with that.
And the clipper shade is broke in our pod.
Uh, all right, just one moment. All right, so this is what I am going to do. The setting date I'm going to give you, the motion for a bond hearing, I don't see, I'm sorry, the motion that your attorney's going to file for a hearing on a bond. I don't think this should last this long, but I just want a date in the system so you're not lost in the system.
Yes, ma'am.
So the date I'm going to give you, it may end up being sooner. Let me go to the calendar here.
No, that's fine, Judge.
Norma, Mr. Howie, if you'll put him for, all right, counsel, are you okay with putting this down for April? You know what? If you can put this down on your calendar for May 5th, but you all perhaps may be able to get in sooner than that.
Okay, that's fine, Judge.
All right, so we're gonna put you down for May 5th. But-
for a, motion for a bond?
for the bond.
Okay.
And it may end up being sooner than
Okay.
that.
Yes, ma'am.
We're just trying to get in
Okay.
touch with the AG's office on that.
Okay, hopefully. Thank
All
you.
right. All right, do you have any questions about anything?
No, ma'am.
All right, thank you so much for your patience. I'm sorry, my hands are tied.
No,
have to
I
follow
understand.
the-
And thank you for, bringing it to my attention, and working man as fast as you could. God, take care and God bless, man.
Oh, thank you. God bless you too.
Yeah, and when I get out, I'll be dressed very appropriately.
Let me just tell you, you are dressed appropriately for the jail because this is what the jail requires, okay?
Thank you, ma'am.
Thank you.
Maybe excuse you.
Yes.
So something this or before.
Yes. All right, just give me a moment. I want to put this in the system.
Well, that's what I'm gonna. Yeah, ask for, yes, like. That's the best information.
All right, Amanda Hernandez. Hello,
Morning, Your Honor.
good morning. How are you doing?
Doing well.
All right. So I have the fraudulent possession of identifying information and possessing the gram. Where are we on discovery?
And I do not know it right now. The answer for that is my granddaughter wanted to help me this morning and she pulled the wrong Amanda Hernandez's file out.
Aw,
And
do
I'm,
not throw her underneath the bus. I will not allow that on this day.
I know. I love her to death. And I probably will never tell her she did this.
No, you will not tell her that. And if you do, I'm going to take you into custody.
Some people do not understand the power of a district court judge. I do, Your Honor. It's-
So your attorney brought the wrong file. So we can recall it. When would you like it recalled?
As soon as possible. The state has indicated that they need to talk to a victim on the family violence case and that they have suggested the 21st of this month.
All right, well, we'll bring you back on April 21st. And Miss Hernandez, if your attorney wants you brought back sooner, then we'll bring you back sooner.
Okay.
All right, thank you.
Just have a seat, ma'am. I'll let her know. Hey, John, yeah, I'll be waiting for you. You guys have it. I can send you down. Thank you.
21st.
Bless you.
Horrible.
All right. Rodney Garza. All right, and I believe this is criminal trial division. Sure. So has it warmed up outside at all?
I think so. I hope so.
And I guess we're not going to see Cornelius Cox. He's celebrating the victory.
Who is?
Cornelius,
Oh,
since
okay.
Florida won.
Oh, cool.
Mm-hmm. You're welcome. All right, the court is calling 2025 CR 0022828 State versus Rodney Garza. Could I have parties announced?
Andrew Harris, Edelman for the state.
And Johnny Cisneros for Mr. Garza?
Are you Mr. Garza?
Yes, sir.
Counsel, have you received all discovery? Did you review it with your client?
I did, ma'am.
Court will find that the state is in compliance with discovery. Mr. Garza, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
In the second paragraph, cause number 397243 should be 39424.
Any objection to that change?
No, ma'am.
All right, do you have any objections to that change to the indictment, sir? All right, Mr. Garza, did you review the court admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. The state recommends community supervision. They're taking in consideration 2024 PF 26950. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community your community supervision be for a term of 10 years. There'll be a TAP evaluation, 200 hours of community service restitution, DWI intervention, VIP live, ignition interlock for half the term, 2-year driver's license suspension. Did you also understand that the court may place you in the Bexar County Jail for 10 days as a condition? All right. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections, Your Honor.
States you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am, please.
Anything you wish to say on behalf of your client?
Judge, we would like for the court to honor the plea bargain agreement. It's been years since my client has been arrested for DWI third or more. And we're asking that the court, well, his mother's very ill also.
Mhm.
So he's a caretaker for her, so we need him out here to help take care of her.
All right. So in taking care of your mother, are you receiving payment from the government for doing that?
No.
All right, because I don't allow people in this court to be home health care providers. You understand? Now, with regards to this 10 days in the Bexar County Jail, I do understand that your mom is ill. So you have a choice. You can do the 10 days in the Bexar County Jail, or either you can serve it on GPS. All right. So are you employed?
Yes, ma'am.
What's your work schedule?
It varies because on events and all that, so right now, schedule like, probably Thursday.
All right, what do you do?
I'm on like my back section or kind of like jack of all trades at the mooring center. I take work.
All right, so this is what I'm going to tell you. If you want GPS for employment, then you're going to be on GPS for 30 days. And it will be for employment only in your mother's medical appointments. That's it. So you will only be allowed for 30 days to go to work. And if your mom has a medical appointment, to take her to her medical appointments.
Okay, and it's just my mom and my dad. And my dad, he's already 87. He's kind of ready to walk to it and all that. So
Okay.
on both of them.
All right. And it appears that you drink approximately every 20 years. What's going on at that 20-year mark that's making you drink?
For this past one, it was the whole past last year was I think like April for Thanksgiving. And my brother passed away, and then my aunt passed away. Then my daughter got stabbed 35 times, and all that. So I guess I think I just.
All right. So here's the thing. When you're on probation, you're not allowed to drink at all. And then it appears that you're one of the people who cannot drink at all. Some people, they can drink, they take one drink and they're like, oh, okay. Or as my grandmother would always say, oh, I just nurse it. I'm like, what does that mean? And it's one drink the entire time. And so in your case, you can't drink alcohol. So you're not allowed to drink alcohol at all while you're on probation. And you should find some other activity. Okay?
Yes.
And Judge, I've gone over all those, all the advice that you've given him
Mhm.
Before with him. He can't drink even at home, anything like that, because just because you're drinking at home doesn't mean that an emergency won't happen. You have to get in the car and drive mom or dad to the hospital or something. So he understands.
Okay. All right. As previously stated, the court is finding you guilty. The court is going to sentence you to 10 years in the prison. The court will suspend your sentence for 6 years. And let me just tell you why I'm suspending it for 6 years. Because I understand that people react differently to tragedy. To have all of that happen in your family and counsel, is what he's saying true?
Yes, ma'am.
All right.
I've known him for years and years.
All right.
In fact, his aunt took care of my dad till he died.
Okay. And so your attorney is the officer of the court. Sometimes defendants will come before me and they will say, oh, well, this person is in the hospital and this person is in the hospital. And I'll turn to their attorney. I said, do you have proof of that? And they will say, no. So as an officer of court, he's telling me that he has knowledge of that. So that is why I'm not giving you a length and following the state's recommendation of a length for 10 years. I'm going to place you on 6 years because I realize that's a lot to hit somebody all at once. And then if you're battling your addictions, it's easy to fall off the wagon, as they say. But when things like that happen, you should already have a sponsor or somebody to call. You understand? So 10 years in the prison, suspended and probated for 6 years, regular reporting by Zoom or in person, regular random UAs, taking consideration 2024 PF 26950.
Approach judge.
Yes. Proof of employment within 30 days. No employment as a home health care provider or with minors. I'm going to do 30 days. GPS partial. Here's the thing about the partial GPS. If you want the fees waived, you'll have to go to the Bear County Jail, correct? If you want the fees waived for GPS and want my order to mean something when I say fees waived, you'll have to report at the Bear County Jail. They're not going to take you into custody at the Bear County Jail, but you'll have to report at the jail for that GPS. Otherwise, if you don't want to do that, you'll have to pay for it. It's going to be approximately 300 or maybe 360 for that month. So what do you want to do? All right, Ms. Abrams. So he said he's okay with waiting at the jail for them to put the GPS on. So it'll be 30 days GPS partial for employment and all medical appointments, of course, for himself and for his mom and dad.
Donna, what date does he have to report to the jail for the GPS?
Let me find out from probation. And I'll ask that the fees be waived. There'll be a TAP evaluation out of custody. And Ms. Abrams, we'll do a referral to felony drug court. I don't know if that's going to be a good fit for him with his parents and everything else that he's doing, but let's see. I'm going to want 60 sober meetings in 60 days. Ignition interlock for half the term. And that's 30 days GPS in lieu of the 10 days at the Bear County Jail. And the court is ordering the 30 days GPS because of the hardship that the defendant would have if he were to serve the 10 days at the Bear County Jail. And also because there are a whole host of health issues at the Bear County Jail. And there's also overcrowding. So ignition interlock for half the term, DWI intervention, VIP live, DWI education, 2 years license suspension, 200 hours of community service restitution, field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else that you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Here's
May I ask one question?
Yes.
Would the court consider allowing him to get an occupational license since he needs to get to work and take his parents and maybe even himself to the
Yes.
doctor? Thank you.
All right. Now, with regards to his reporting to the jail for the GPS, Ms. Abrams, when would be the best date? Okay. All right, so they'll discuss with you concerning that. Now, this is what I'm going to tell you about DWIs. I have yet to have somebody stand before me or to have a client say, you know what, my intention when I got up this morning was to go out to drink until I was intoxicated and to kill someone. But every day in Bear County or somewhere in this world or in the United States, somebody is drinking and driving. They either hit somebody and kill them or change that person's life forever by hitting them and injuring them. This case could have easily been where you're driving, you have all these problems that are going on in your life. And believe me, other people are driving, they have a lot of problems going in their life too. And if you would have hit them and injured them or killed them, you'd have just compounded the problems they already have. So don't be that person. You understand? In this court, to be successful on probation, communication is key. If there is an issue, let your probation officer know about it. If you feel that the probation officer is not listening or not addressing it, you can always come back to court. Do you understand? All right, good luck to you.
Okay, thank you.
All right, thank you. Thank you,
Gracias,
counsel.
Juanita.
Oh, thank you. Look, everybody's calling me señorita now.
Thank you. Thank you.
LaShawn, pay attention to that. Everybody's calling me señorita.
Thank you, Your Honor.
Thank you. I'm like, yeah. Arminio Rangel. And probation, this is an application as well. Court is calling 2024 CR 009895-03, State versus Arminio Rangel. Can I have parties announced?
First manager for the state of Texas.
Good morning, Judge Alfonso Cabañas from Mr. Rangel.
And are you Mr. Rangel?
Yes, I am.
All right. Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rangel, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, I did, Miss.
And did you review the true bill of indictment with your attorney?
Yeah, yes, I did.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Proceed on count 2 indictment and we'll waive count 1.
Any objection?
No objections from defense counsel.
Did you review court admonishments with your, and okay. Did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, I did.
All right, you're charged with injury to a child or elderly or disabled person, bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
He did, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, that's right.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at a cap of 4 years in the prison. There's a $1,500 fine. State will be silent on your application. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am, I did.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of your plea?
Yes, miss, I did.
Defense,
Yes, Your Honor.
state?
Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, there been any such motions?
No, Your Honor.
Then to the offenses charged in count two, how do you plead? Guilty, not guilty, or no contest? State any evidence?
One, all attachments.
No objection to states one and attachments, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did. Miss.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. State, have you had any contact with the complainant? All right. And do you have any input? Well, I know they're silent. Do you know if they're objecting to his having deferred?
Would object to the third, Your Honor, yes.
Okay, all right, thank you. And the reason why I'm asking that, counsel, is to see if this can be taken care of today.
Yes, Your Honor.
All right, let me review the documents. For deferred adjudication. And counsel, how old is your client?
62.
62, Your Honor.
And let me see the complainant's age. All right, so they're going on an injury to the elderly, bodily injury or disabled person. I don't know. He's not disabled, correct? All right, the elderly part. All right, if you all want to, I can reset this for sentencing, do a PSI. PSI is going to take about 8 weeks. Or if y'all want to call it back sooner, I can ask that the complainant appear and I'll make a decision on the application.
George, if we can do it back sooner, depending on the court's availability, I would appreciate that.
All right. Oh, the complainant is here. Do you all want to proceed with sentencing now?
Yes, Your Honor.
All right. Let's bring the complainant up.
I'm right here.
Hello, sir.
Yes, ma'am.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Okay.
All right, you can lower your hand, state your name for the record.
Joey Ramirez.
So state, I know you're silent. Defense, any objections to the court asking the witness questions, or would you just like to ask questions?
No, Your Honor, no objection to the court.
All right. So how long have you known the defendant?
Oh, like about 15 years.
All right. How did y'all first meet?
Well, I used to buy drugs.
Okay.
I met him at a connection.
All right. And let me just tell you about that. Everybody's life starts on a certain place, and hopefully we're improving it. Okay. So you all have known each other for 15 years. How did it come that he lived with you?
Well, he drove up on me one day and he said, I need a place to stay for about 2 weeks. And I said, oh, okay. 2 weeks, okay. And then he came back and he told me, hey, well, I'm not gonna make it. Can you give me more time? So yes, okay. And then he had told me that if he needed to leave, he would. Like my kids wanted to come back home, he would get up and take off, no questions asked.
Mhm.
You know, I'll leave. You leave the room back because of your kids. And the deal came up where they raised the rent and
And so the children were going to be put out and he wanted them to come stay with him?
my grandson, his wife, and the two kids, and my daughter needed a place to stay. Well, I got a home, you know, and I've held my home because in case of an emergency.
And so you want him to leave because, and it's understandable. So you wanted your daughter, the grandchildren to come because their rent had been raised.
They didn't have money to pay.
Mhm.
And-
Oh, no,
and-
I understand.
And then I told him, I said, remember what you told me when you came?
Mhm.
And that if you needed me to get up and leave, I would leave. So, and he didn't say nothing. And
So this is what I want to tell you. So he's asking for probation. And I have a choice to make. If I give him probation, he can't stay with you. I'm not going to allow him to contact you. So his driving by to talk to you, whatever friendship you had with him will be considered over because I won't allow him to contact you. Do you understand?
that's what I want to.
All right. So I'm leaning towards giving him probation, not allowing him to come near your home, not allowing him to contact you at all. All right. Do you have any problems with that?
No, I don't. You know.
Okay.
I
Now, let me ask you.
You know, whatever has coming to him, well, it's okay. And then, you know, I'm sure he understands the consequences now, you know.
Let me ask you this. Did you have any bills related to this?
Well, I got insurance, right?
Mhm.
And I use my insurance.
Did you have to pay a deductible?
Yes.
What's your deductible? How much was it?
Ma'am, I don't know, to be honest.
All right, so here's the thing. You don't have to give it to me now. What I'll do is I'm going to order him a defense.
Yes, Your Honor.
If there's a deductible, I'm going to order that your client pay whatever the deductible was.
Yes, Your
And
Honor.
because I'm looking at the injury, the mark on the face, I don't know if EMS was called out for the mark on the face or not, but if EMS was called out or you used EMS for this, he's gonna have to pay for that, because I know that's
Oh, yes, I
expensive.
think I got a
Okay,
bill for that.
all right, so what I'm telling you, defense, there really is no need for a restitution hearing. If there's a deductible and you give the state proof of the deductible, he's paying for it. If you give the state proof of the EMS bill, he's paying for it. You understand?
Yes.
Now, with regards to the room that you allowed him to live in, were there any damages to that room by him?
No.
Okay. Is there anything else that I can do with regards to conditions for him that would make you feel safe?
I believe this was enough,
Okay.
you know, that he did what he did and I did what I did. And that's it, you know.
Okay. Well, thank you. Let me just tell you, number one, thank you so much for dressing appropriately for court.
Yes, ma'am.
I truly appreciate that. And thank you for giving me some insight into your relationship with him. And now I understand, because sometimes there are not things in the police report, and I always want to know about that. But I will tell you this, if somebody comes to live with you and you're allowing them to live with you, they really should understand. At the end of the day, if my children need to be here or my grandchildren need to be here, they're going to trump your being here. So thank you so much, okay?
Yes, Your Honor.
No, thank you. All right, Mr. Rangel.
Your Honor.
When somebody asks you to leave their home, you need to leave their home. Because at the end of the day, unless somebody has children like the children from Children of the Corn or Rosemary's Baby. And even in Rosemary's Baby, Mia Farrow was like, no, this is my baby.
Yeah.
But at the end of the day, their children are going to be chosen before you. They're going to be put above you. The grandchildren are going to be put above you. And when somebody asks you to leave, maybe they should give you some extra time to leave, but maybe they won't. No. Do you look like you losing this case? Do you want to lose this case? All right. So this is what the court is going to do. The state was asking for a cap of 4 years. I'm going to give you your deferred. If you are unsuccessful on it, you're looking at 10 years in the prison. Do you understand? So here's your choice. If you want to go along with the cap of 4, I will sentence you to 3 years prison today. Otherwise, you're going to be on 8 years deferred adjudication probation. Which would you prefer? The 3 years in prison or 8 years deferred?
8 years deferred, please.
All right, so it's going to be 8 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment or SSI within 30 days, no employment as a home health care provider or with minors. There's going to be restitution to the complainant. Joe Ramirez for the EMTs and also for whatever deductible. And of course, defense if the insurance paid for the EMTs then. And there's to be no contact with Joe Ramirez or the location. And counsel, I need a trial court certification. I don't have that. Or Park Village, San Antonio, Texas, 78227. Field visits, 1 time per month until further notice. 200 hours of community service restitution. I'm going to order anger management. Once anger management is complete, then the community service hours will be deemed satisfied. There's an affirmative finding of family violence. There's to be a $1,500 fine, and that will be probated. Probation, is there anything else? Is there anything else you need from the court to be successful?
Well, I'm on methadone. I've been 4 years clean from heroin.
All right, there's going to be a TAP evaluation out of custody. I'm sorry, TAP evaluation and a referral to felony drug court in custody. Well, congratulations on your sobriety. I
Thank
appreciate
you.
that.
Thank you very much, miss. God to give me, only God can get me there, miss.
Yes. All right, do you have the trial court certification?
Judge, I believe it should be,
I don't see it unless I'm missing it. It's not in here.
Judge, I was given an extra one. We'll sign it.
All right, thank you. And state, thank you so much. All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you, Your Honor.
Thank you. Brandon Banks. And don't put any more cases up here. Okay. Court is calling 2024 CR 009618 State versus Brandon Banks. Could I have parties announced for the record? State. Defense.
Matt Stolhansky for Mr. Banks,
And are you-
although, may I say, Your Honor?
Yes.
I've substituted in for Judith Wimmert. I talked to Judith. It shows her name on the papers, but I'm proper attorney.
All right. Do you have any objections to this attorney standing in?
Ma'am.
And are you Mr. Banks?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Banks, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Repeating, we're waiving the repeat offender enhancement allocation.
And we have no objection to that.
All right, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of evading arrest or detention second or more as a state jail felony? Range of punishment is anywhere from 180 days to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Banks, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. State recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That's it, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, ma'am.
Outside the agreement, the state is recommending a TAP evaluation and that your community supervision be for a term of 3 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State evidence.
Containing exhibit 1 and attachments, Judge.
Your Honor, I reviewed my client. We have no objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Just that Mr. Banks has some mental health issues. He takes, what are the drugs you take?
Haldol, Elavir, just depression, antidepressant.
Okay.
So I didn't know if there's some help that we could get for those
Yes.
things.
All right, this is what the court is going to do. Do you have any children, sir?
2 daughters, ma'am.
And what are their ages?
16 and 14.
And do they live with you?
No, ma'am, they live with their mother.
All right. And who is your support system?
My wife, Amber Banks.
All right. This is what the court is going to do. The court is going to sentence you to no contact with Lauren B. Maldonado, Frank Andy Hernandez, and the street San Patricio in San Antonio, Texas, 78207, and the street Heinz, Henze Road. What is UBC? Is that universal?
You see,
UBC, Texas.
I don't,
Somebody help me. What is UBC in Texas? What state is that?
Unincorporated Bear County, Judge.
Oh, thank you.
good win.
All right, then somebody's giving him kudos. Thank you, Andrew. Give people an A+ when they deserve it.
I'm telling you.
So UBC Texas 78223. The court will sentence him to 2 years in the state jail facility, suspended for 3 years. Regular reporting by Zoom or in person, regular random UAs, TAP evaluation, and MIC evaluation in custody, followed Rex. Are you employed or do you receive SSI?
I'm working to get my check. I mean,
All right, proof of employment within 30 days of release, no employment as a home health care provider or with minors. 100 hours of community service restitution. I'm gonna order anger management classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Know better, do better.
Yes, ma'am. Yes, ma'am. Thank you.
All right, you're
Have a
welcome.
good day.
You too. Who's here on Israel Medellin? Is Israel Medellin on the docket today?
No, ma'am.
All right, that's gonna have to come back on another day. Anything that's not on the docket today is not on the docket today. Who's here on John Hayes? Is this on the docket?
Yes.
All right, come forward. Are you ready to proceed?
Yes, we are, Your Honor.
Court is calling 2023 CR 3545 State versus John Thomas Hayes. Can I have parties announced for the record for the state?
I further appeal for the defendant, John Thomas Hayes, Your
And
Honor.
are you Mr. Hayes?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same John Thomas Hayes who was placed on deferred adjudication in 2023 CR 3545 for the offense of violation of bond protective order assault stalking on November 4th, 2024 for a period of 6 years? Is that you?
Yes.
State?
Yes, the state will proceed on violation of condition number 25 on or about the 20th day of March 2025 in Bear County, Texas. The defendant, John Thomas Hayes, did then and there contact or attempt to contact Samantha Hayes or a family member by telephone, mail, or in person in violation of condition number 25.
How do you plead to that? True or not true?
True.
The
State?
state will waive the remaining violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 25, the court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison, up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 25?
True.
So do you still wish to continue with your plea of true? Court will find violation of condition number 25 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
The agreement was to plead true, and if the court so allows, to enter an adjudication. I'm sorry, to amend the conditions for state ISF, followed by ISP supervision for aftercare treatment and mixed supervision, which is probation's recommendation as well.
All right, so why is he contacting somebody that clearly he was ordered not to contact? And I put in here, no contact with Samantha Hayes. And I know that when I tell people no contact, I always say, no letters, no cards, nothing. So why is he contacting someone that the court ordered him not to have contact with?
Part of the issue, Your Honor, is that Ms. Rubio, Samantha Rubio, makes contact with him. And Mr. Hayes has some mental health issues, not the best where he can make best decisions.
So part of the issue is that she makes some of the contact and they have a 2-year-old daughter that,
People just having children with anybody. Okay. So here's my thing. Unless Samantha Hayes or Samantha Rubio or whoever she is, she needs to come to court.
Your Honor, and if the court will allow, I will, go to the court, if there's no objection from defense counsel. We did speak with her about, the contact that defense counsel was talking about. She did say that she did make that contact. She said that she was intoxicated at the time and she was, lonely, and so she was reaching out to the defendant on those dates that defense counsel has. However, she does not want contact with him, but would prefer him to continue to be on supervision and get treatment.
So, where is Child Protective Services? We got somebody who is intoxicated, taking care of a 2-year-old. And meanwhile, we have somebody who everybody is saying who has mental health issues or whatever else is going on with him. And he can't follow the court's orders that he's not to have contact with somebody. And these are the people that are raising a 2-year-old. I'm not taking, she needs to zoom in or either she needs to come in, because I don't know why people do these things. And back in the day, when people would have protective orders against people, people would violate those protective orders, show up at their home anyway. And you know what the police would end up saying? They're not here now, so we're not filing any charges. Now, there are other things in place. I'm not saying it's the best. I'm not saying it's perfect, but they have in place no contact. And then you have the complainants violating the no contact order, then come into court crying, don't put them in jail. So she needs to appear by Zoom or in person. Otherwise, this violation of condition number 25, even though she reached out to you, you're going to prison. Because I said no contact. So I'm accepting his plea of true to violation of condition number 25. This is going to be reset for next week, and she can appear by Zoom or in person and explain to the court, what is she doing? Is she giving him the carrot and the stick? Here's the carrot, come contact me. And then here's the stick, let me report it. Like, did she report that he was having contact with her? Is this how this came about?
Yes, Your Honor, my understanding, in speaking with our complainant, is that all of these violations happened before the contact that defense counsel is talking about. And it was because of the contact from the defendant that kind of got her heart, in the position it was to reach out to him.
Well, she needs to be here. She needs to be here by Zoom. And I need to understand what's going on. Because who knows, maybe he shouldn't be on probation at all if she's going to continue to contact him. Norma, recall this for the week of April 14th. What date? All right, we're coming back on April 15th. Thank you.
tax day.
May I have excuse you?
Yes.
Thank you.
Sarah Juan Castaneda. Hello. Good morning. What is happening with this case?
I am asking for a reset, Judge. One is I've been dealing primarily with Mr. Garahan because the probation cases are with him. And we were real close to an agreement. However, he has some other situations that I'm now dealing with Ms. Jones on. And to kind of cut to the quick, we need to come back because Mr. Castaneda is going to have to do something
Okay.
before we come back to enter our plea to the court and ask for what we're going to ask for.
So when are you asking?
I'm trying to find out when he has a case that's pending. It's a misdemeanor. I'm trying to find out that court date, and I would like to do it around that court date or shortly thereafter.
Which court is this?
It's in County Court 13 Impact. We were just there about a week ago, so he's probably been rescheduled for about 3 weeks from today.
All right, so if you want to find out when that's going to be reset, I'm going to recall this back on April 17th. And then if it's a different setting down here, your client needs to come up with you and then we'll give you a different date. But for now, it's going to be April 17th.
17.
Yes.
Okay.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
No, him for dressing appropriately.
But
for
I
court.
was saying thank you
You're welcome.
because that's the kind of guy I am.
Uh, Who's here on Daniel Hernandez? I'm sorry, what?
Oh, it is?
Oh. Yeah, but did you all speak to the state? Because I think they have witnesses here. No? Are you all ready to proceed on this?
Yes.
Court is calling 2023 CR 10712 State versus Daniel Hernandez. Can I have parties announce state?
Andrew Harris, Edelman.
Defense?
Warren Wolf.
Are you Mr. Hernandez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Daniel Hernandez who was placed on deferred adjudication in 2023 CR 10712 for the offense of assault of a peace officer judge on February 20th, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
On or about the 24th day of March 2025 in Bear County, Texas, the defendant Daniel G. Hernandez did then and there fail to continue treatment with Dr. Koresh and provide release of information in progress in violation of condition number 21.
How do you plead to that? True or not true?
True.
State weighs the remaining violation allegations. John.
Did you understand by pleading, any objection to the waivers?
No.
Did you understand by pleading true to violation of condition number 21? Court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 21?
Yeah.
Court will find violation of condition number 21 true. Is there a proposed agreement?
Yes.
And what is that?
Not an motion. Not a mental health assessment and transfer to mixed supervision if he still qualifies.
All right, thank you. Was that the proposed agreement?
Yes, Judge.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Daniel G. Hernandez.
All right, why are you not signing over so that probation can have contact notes or have information on your treatment with the doctor?
Wasn't intentional, Your Honor. It was a change to a different doctor.
Mhm.
It just didn't, it didn't do it intentionally.
So do you have any problem signing that?
No.
Probation, is this your recommendation?
Your Honor, the recommendation for probation department is to complete another mental health assessment and transfer to mixed supervision.
Okay. And do y'all want the mental health examination in custody?
Prefer it out of custody, but
Probation in or out of custody?
In custody.
All right, how long is the MIC evaluation?
Initial evaluation should be completed within 2 weeks, depending on what that outcome is. It's gonna be longer, maybe has to go to Tacoma.
All right, so I'm not gonna ask that he go to Tacoma. I just want the MIC evaluation to see if he will be appropriate for your caseload.
So Judge, the concern we have with him being on the mental health caseload is he has a compassionate use prescription for marijuana, but that marijuana usage is over the usage that is in the compassionate use. So with that, he couldn't be transferred to MIC because of the continued THC use. The levels were increasing, they weren't decreasing.
All right, so do you want MIC in or out of custody? And
Judge, we can do it out of custody and then we can see what they say as far as the the use is concerned.
What about the TAP evaluation? Does he need an updated TAP?
Yes,
Because,
Judge.
all right, so the court will deny the motion, alter amend conditions to include Mick. That can be out of custody, but the TAP evaluation needs to be in custody. And the reason why is because obviously there's more going on here. And the TAP evaluation will let me know. And the TAP evaluation, that will be completed sooner than the MIC evaluation. It doesn't take long for the TAP. And once the TAP evaluation is completed, Ms. Abrams, before they do the report, he can be released and he can be brought back to court for TAP recommendations. All right, thank you.
And you.
Sir, you need to follow the rules.
He does have a back board.
Yes, so he's going to custody. And then he's to be released once the TAP evaluation is completed.
How soon can that tap be done?
You'll have to talk to probation.
Because he is working, you know, and I understand there was some discrepancy. I have his descriptions.
All
He
right.
is being seen by another doctor now.
Okay, if you'll talk to probation, they'll give you a time frame on that. But as I said, TAP evaluations are relatively quick. Okay, thank you. If you need anything, let the court know, all right? All right, the court, Robert Thompson, your motion to reduce bond, Mr. Leal. We'll have we'll have Judge Nahara hear your motion to reduce bond. Oh, all right, then that's gonna have to come back tomorrow.
Tomorrow, I
Yes.
have a full flight tomorrow. I can do it in the afternoon, Judge.
No,
Or
we're
this
in,
afternoon.
we're in a jury trial. If you want, once you get the paperwork done for him, you can zoom in tomorrow.
So me?
Yeah.
Okay.
But the paperwork needs to be done today. All right, the parties on Allen. Hi.
Geez, it's for a sentencing, Your Honor. I got stuck over 386. So I was hoping to bring it back tomorrow morning or whenever you would like to do it.
All right, State, are you okay with recalling this for tomorrow? It's Allen.
Oh, it's, no, it's CTD.
Are you okay with recalling this for tomorrow?
Sorry, sentencing from last
I
week.
have no idea.
All right, so
Whatever you want to do, Judge.
are the people on the front row, are they a part of this hearing or no?
No. I do have one witness that's on the second row.
All right, are they on the PSI for Allen?
No.
Yes, I think.
All right, so on Allen, we're gonna come back tomorrow
Thank you, Judge.
at 9, but I'll need you all here exactly at
Will
9.
do. Will do. Thank you, Judge.
You're welcome. All right, and then I think that's it, because I don't have any other files. All right, and who is that? Yeah, that's,
That was my mistake, Judge.
all right. All right, counsel on that one,
Yes, sir.
your client, I'm assuming, is in custody, correct?
Right there, Judge.
All right, so, I can hear that tomorrow or either Nahara can.
Can we do it with his grandfather's?
Yes,
Okay.
just speak with them.
Okay.
I'm sorry, we start jury trial at 1:30.
I'm good. Thank
Okay.
you, Your Honor.
Thank
With
you.
that, may I be excused to Judge
Yes.
Nahida? Thank you, Judge.
Mayor,
Yes.
I have Jesse Garcia.